Now it's question time. We see a number of questions I've received. So let's first deal with some of the questions in the order that we received. On a claim against an accounting firm for negligent investment advice, what can be done if the plaintiff has discovered the damage after the statutory period? Rishi, would you like to answer this question, Rishi?
In Malaysia, now the amendment has come into force on 1st of September 2019. It's a very, very early stage. Okay, we expect that the reliance on the new Section A would apply insofar as something like this is concerned, because it's very specific to say that as long as it's non-personal injury, the assessment for limitation period will be the 3-year period as opposed to the previous Section 6(1), which is the blanket 6-year period. So while Section 6A, the purport of Section 6A was brought about by latent defects claim, that does not mean that it would not extend to something like suing an accounting firm for negligent investment advice. Okay. In UK, for example, the Court of Appeal, has specifically applied something like this to allow for the extended period pursuant to their recent Section 14A Latent Defects Act, and they have applied it to the letter of the provision. It will be interesting to see whether our courts will apply Section 6A by taking guidance from Section 14A, because those two sections are pari materia. That means the purpose of Section 6A, the basis, the rationale for Section 6A was brought about by the Latent Defects Act in UK. So we will have to assess that. We will have to see the attitude of the courts in applying that. That is yet to be seen. That is all, Dato.
And could I add, I don't know how many of you read the online edition of Age today. It reported a claim that has been filed against a very large accounting firm for negligence in the auditing, and this is one of the 1MDB cases, and the 6 years have passed by. The audit was done in 2011, 12, 13, that period of time. Yet a claim has been filed relying on Section 6A, because the company at the material time was not in a position to initiate action. Against professionals, against whether they are auditors, whether it is negligent advice, solicitors, if the company is in a disability, not the disability that Rishi was talking about, but you were not able to initiate action, then the 3-year period in Section 6A is effective. With that, we'll look at the second question. Rishi has already answered the second question. When does the limitation period come into force? Rishi, could you repeat that again, Rishi?
Yes, 1st of September 2019. But if I may just add, one has to be mindful of a potential retrospective effect. Again, we'll have to assess to see whether the courts are going to deal with it by leaning towards the previous Section 6(1) or the new Section 6A, insofar as transactions materialized as at the 1st of September onwards. So is it going to be a 15-year period assessment, or is it going to be 6-year period assessment? That is yet to be seen.
Second question, the other question is, how long and when does the right to receive money accrue for foreclosure proceedings? Foreclosure proceedings are all, I will answer that question, Rishi. Foreclosure proceedings are all dependent on the term of the facilities. When did the money become due and payable? That's the first part. Second part is the charge that has been created, is it a first-party charge or a third-party charge? If it's a first-party charge, then it is when the debt became due. But you remember, we have a very special provision in regard to property claims. So we have got that as well. So it all depends on the terms of the charge and the basis on which, whether it's a first party or a third party charge. But the essential position is, when did the money become due? It is still the same position is for guarantees. If it's a demand guarantee, unless a demand has been made, the cause of action doesn't accrue because it's a demand guarantee. The precondition for such a guarantee is you must make a demand, a valid demand, and it's only the limitation period starts from that time. Rishi, have you got anything to add on that, Rishi?
No, I don't.
Okay.
I don't have anything to add.
The next question is, how is the limitation period calculated if there is more than one disability suffered by the prospective claimant? That's an infant with a mental disability. Rishi, I'm sure you could.
Yes, Dato, that is actually a very simple answer. It's contained in the Limitation Act, Section 24 sub 2, says that once both disabilities have ceased, only then the limitation period will commence, and that is the assessment.
Yes, and that makes common sense as well. If there is two legal disabilities, one in infancy, one a mental disability, you cannot say that the moment the man becomes matured, the infant becomes adult, he should be entitled, he should bring the action, because even if he were an adult, he is still suffering from the mental disability. Therefore, it must be the later of the two. Then Rishi has also touched on whether a signature is compulsory for the acknowledgement part under Section 26, 27 of the Limitation Act. Rishi, could you repeat that, please, Rishi?
Well, signature is compulsory, but in terms of the Electronic Commerce Act, it does not need to be written per se. Any mark which is identifiable as a signature, we have digital signatures today, that can be acknowledged to have a valid and binding force. That is
there is another question for you, and it's addressed specifically to you. In relation to Papa, what is the act complaint of was not done in pursuant to public duty?
Okay, if it is not done pursuant to public duty, then the assessment falls back to a limitation, the pursuant to the Limitation Act or the specific legislature which applies. You know, for example, if you have a situation where you are dealing with, nothing comes to mind outside the Limitation Act, but okay, we do deal with specific factual premise within the Limitation Act. The assessment will have to be made to that extent. Is it a contractual claim? Is it a tortious claim, taking into account Section 6A now? Is it something which relates to a claim pursuant to an estate of a deceased person? Because I've touched on earlier in my presentation, limitation period between 6 years, 12 years, and 3 years. But there are situations in which it could be also 1 year, you know. So it will be very important to assess the factual matrix. If it is not something complained, or the act complained of was not done in pursuance of a public duty.
Saravana, there is a very interesting question. Before I deal with the issue of COVID, force majeure, and all of that relating to limitation periods, there is a question. IRB has requested documents in regard to time bar assessment. Does the taxpayer have the right not to furnish this information on the basis it's all time bar?
That's a good question, because the irony is the time bar assessment is 5 years, but document retention is 7 years. So I am of the view that as long IRB asks for documents up to 7 years, and it's got to do with assessing your chargeable income, I think you're still obliged under the Act to provide those information. It is beyond the 7-year period that is very interesting. It's yet to be challenged, but in one of our earlier seminars, Dr. Naban, we said, well, if you like to challenge revenue, you're more than happy to mount a challenge for that. So my answer is 7 years you got to give, I think.
Okay. After 7 years, you have no opportunity to. But the act requiring you to disclose information, allowing IRB to come to your premises, all that has no limitation period.
No limitation.
Yes.
No.
Yes. Therefore, you must remember, if you have destroyed all your documents after 7 years, then you don't nothing to disclose. If you have documents, it doesn't prevent revenue to coming in. My question is, can we say I'm not going to disclose after 7 years?
Yeah.
Yes, that's a challenge. There is no decision yet. It is something that when there is an interesting case, I'm sure Saravana will raise it.
Yes.
Then the next question is on a transfer pricing issue. Interest-free loans between associated companies dating many years. Apparently, it is not at arm's length, and transfer TP documents have not been prepared. Can IRB raise assessment beyond the limitation period, relying on Section 91C?
Yeah, because I think they can, because here, if you don't prepare documents properly, and assuming the Section 140A is already in operation, which is 2009 onwards, then it's a bit more difficult. Then wouldn't revenue prima facie may have a case to say that you are negligent. But if your transaction is 20, 30 years ago or 10, 15 years ago, then revenue can't invoke 140A. The only other provision they can invoke is 146. There you got to prove that had you dealt with a third party and you would have transacted in the same fashion, I still think you got a basis to argue that you're not negligent. So revenue can still raise, but whether they can establish negligence or not is a different question.
Yeah, and in such a case where you do not have documents, it is legitimate for you to say that these were these are things that we could have brought in, and you cannot be in a disadvantage merely because revenue brought the assessments much later. Again, these are matters that has not had cases, not many cases that has been reported on limitation under Section 9. Yeah, is that right, Saravana?
Yes.
Yeah.
Yes, you're right. The irony is we don't have English cases on time bar and all that. It's all Malaysian cases only. So I guess the authorities in the more developed countries are observing timeline and doing the audit, diligently and quite quickly. But Malaysia, they do audit diligently. I will not say no, but they stretch it to time-barred years, which I think is not very fair to taxpayers.
Rishi, there is a nice question for you on how does COVID situation affect limitation periods under the Act? No cases yet, but you try and state what your take on this is.
This will be, yes, my take on it, Dato. And I will say this: these are two statutory related provisions. So we'll have to see to what extent the court exercises any element of subjectivity premised on factual matrix, case-to-case basis, which they will have to do, to see how they are going to exercise discretion, if at all, or are they going to take a very hardline, strict, robust approach, which, to my mind, will run foul of overriding objectives of fairness, justice, so on and so forth. But these are something which we expect to deal with once the Temporary Measures Act is over. For now, we do not know. Until the end of the year, we just have to wait and see. That is all.
Yeah. COVID. How does COVID affect performance of contract? That generally, if you have a force majeure clause, that will deal with it. But if you have a limitation period and that has expired during the COVID period and you did not initiate action, then question is, do you come within Section 6A? If you don't come within Section 6A, were you suffering a legal disability? I really don't know, because if you remember, courts are open still. Law officers are also open. although we cannot function 100%, we are a limited period, but for the general public, if you have a claim, does COVID prevent you from seeing your lawyer, initiating a claim, for the lawyer to file the claim? These are all the difficult questions you will have to face if you allow limitation period to expire during the COVID period. So you just remember that. And Saravanan, this is a nice question for you.
Yes.
What is the limitation period for the customs recover GST?
I was just about trying to get hold of what you call of my repeal act. Ordinarily, if I'm not mistaken, 6 years. But let me just have a look at the repeal act and come back on that on a more definite answer, firmer answer. But I wanted to answer this question.
Yes.
That is, if I may read the question.
Yes.
If the IRB knowingly raises an assessment which is subsequently proven to be time barred, would the company be able to lodge a complaint of negligence in reverse against the IRB? I was thinking, if I tell the officer that your assessment is time barred, he doesn't bother, he raises it, could I then go after him in civil court for a civil claim for all the loss, the trouble he has cost me? For instance, the legal fees I've incurred to fight the revenue and win the case. I thought this time sometimes when officers abuse the authority to be made accountable for their conduct, especially when they know very well and don't give you reasons and they just come and raise the assessment until you pay. So I was thinking that if any taxpayer willing to take that particular route, the nearest we had was one taxpayer where he wanted to sue about 60 officers with our Rosli. When they investigated and froze his bank account. But the moment they saw the affidavit, they lifted the AMLA order the following day. They never had a chance to go to court to test it, To what extent an officer who abuses his power can be held accountable. I'm not saying about judicial review, but maybe in a civil court, to find a cause of action in law for that.
If you remember, I don't know how many of us friends who are participants who are listening to us will remember the man under whose name Saravanan is one of the names named the partner. The other person is Rosli Dalan. Rosli Dalan, some years ago, a charge was brought against him, and he took the position that charge was an abuse of process, was maliciously done. And he sued not only the police officers, he sued the DPP who was involved in the framing of the charges. He sued all of those people who were involved in the investigation. And the government settled the case. Therefore, there may be a good basis if we can prove it is done maliciously without any basis. There is another question, Saravanan, for you. For time bar cases, if we won a case in court for these years, can you read this question and answer it yourself, Saravanan, please?
If we won the cases in the court for the years 2003 to 2008, for example, we can only claim CA of 3%, but we already claim 10%. Should we adjust the computations from 10% to 3% CA from 2009 to reflect 2008 and adjust onwards to 2010 to 3%? So I assume the question is not so clear, but I guess he's saying that if we won a matter in court, can they then go and adjust their CA claim accordingly? I think they should too, but I thought when you win the case in court for all the time barred years, court will make an order that all your assessments are to be corrected accordingly. So make sure that when you go to court, you draft your prayers correctly so that the remedies you get covers all those years. Otherwise, you get into an issue whereby no order is done and you got to go and do all these processes. So your pleadings are very important when you file for remedy in court.
Then we have got a question from our dear friend, Chandra. I hope he is in good health. The question is, if IRB invokes 91(3), is there a requirement to show what is the actual wrong that is alleged? fraud, willful default, or negligence before the case goes off an appeal, each of which may be different in severity. That is, if the taxpayer is not notified of what he is guilty of, how could he even defend himself? I'm sure Saravana can answer this.
Yeah, unfortunately, case laws don't seem to have addressed that. The burden is for the revenue to discharge at the special commissioners. So there is no requirement for them to establish it before when they raise the assessment. But I think they should at least tell the reason. Like in the InfraQuest case, the court said the revenue should tell the taxpayer the reason and give the taxpayer the opportunity to respond to it. But the ultimate burden, I think the forum would be the special commissioners for the revenue to discharge the burden.
Yeah, and the other is, as Rishi pointed out to us, limitation does not result in the claim becoming no longer in existence. It is something that the taxpayer or the defendant must raise. If you don't raise it, that's when the problem comes. In civil law, under the Limitation Act, the law is very clear. If you don't plead limitation, you cannot raise it. You got to plead it. In tax law, it is a little uncertain because Section 91 starts off by saying you limit revenue can only raise it from, in the old days, 6 years, next 5 years. Exception is 91C. So maybe there is a basis for Saravana to raise the issue that they must inform you in any statute bar limitation what is the basis. Otherwise, they have got no power. And if they don't say it, maybe it's effective. I'm sure Saravana can think of some nice, smart arguments towards that.
Yes. And that brings the question by Havinda. LHDN currently tends to push cases in dispute to SC, Special Commissioners, including cases where time-barred assessments. Meanwhile, taxpayers have to pay taxes, as Sarah pointed out. Appears to be a tactic to delay dispute resolutions and giving refunds to aggrieved taxpayers. How does judicial review help, and is it a better option in the current environment? I guess, it all depends on the amount of tax. If they want you to pay, they ask the taxpayer to pay $100 million in the current environment, I don't think so the taxpayer is going to pay. And judicial review seems to be a solution, at least a short-term solution, to get an interim stay order, and so that you don't have to pay your taxes. So I know we've been very fortunate. You can see in the papers and in my social media posting the cases where we are getting the stay. Revenue claims that they're winning many cases and they're not getting a stay, but I don't know what cases they are. But the one that we are doing, we're quite fortunate. Most of it, we do get the stay. So, Havinda, it all depends on the taxpayer and the amount of tax in dispute.
There's another question for you, Saravana. If the IRB knowingly raised an assessment which is subsequently proven time-barred, would the company be able to lodge a complaint of negligence in reverse against IRB?
Yeah. I'm sure all this should be done because I guess such officers should be made accountable. And I guess when you lodge a complaint, hopefully they don't get promoted and become, Ketua Pengarah or Timbalan Ketua Pengarah one day. Imagine the little Napoleon that raised the time-bar assessment, 20 years down the road becomes the Pengarah or Ketua Pengarah, and he's free to do what he wants to do. So I guess maybe, it's a good suggestion. I never thought of it from that way, but now I'm going to do that. So when we win the case at the Court of Appeal, write a letter to the DG and say maybe the officer should go for retraining to get his basics right.
Remember, Saravana, the case that you cited, the InfraQuest case, we proved, I think with reasonable certainty, that it was revenue that was negligent in not raising the assessment.
Yes.
Because our client in that case was with a state government corporation. They did whatever they are supposed to do, all fairly diligently, and revenue slept on the obligation to raise.
Yes.
So during cross-examination, we raised this issue, and unfortunately, the special commissioners ruled against us. Not only ruled against us, they said revenue don't have to be not negligent.
Yes.
That is, you remember that?
I remember.
Yeah. And fortunately, the judge in the Court of Appeal, judge corrected it, and on Court of Appeal, it was affirmed. Judge's decision was affirmed.
Yes.
Yeah. then we have got a long question for here, Saravana. Could you manage? IRB has conducted a tax. Can you read the question?
IRB.
Can you read the question?
Yes, I can see. IRB has conducted a tax audit for my client from 16 to 18, and they also look and ask document for 08 to 015. We are in the midst of discussion at IRB. They agreed to come back after FCMU. Suddenly, they issued JA for the years 2008 to 2010 and emailed us. Our client has submitted RPGT and IRB has disputed and wants to tax on income tax. We informed time bar issue, but they said for income tax versus RPGT, there is no time bar applied. They are silent on a negligent matter. Can IRB do this? Can I appeal on zero penalty on the ground of technical issue? In the first place, is time barred. Why you want to focus on penalty? You should get the whole assessment to be set aside. But of course, there is no such thing that income tax and RPGT issues, no time bar applied. Perhaps officers like this, eventually when a matter goes to court and you win, you should write to the DG and ask them to be retrained so that they get proper training in law. But it's very unfortunate. IRB is doing that now. During FMCO, they're raising these assessments when many taxpayers are unable to go to office because some are not everybody is in essential service now. And they're insisting on documents and so on. Although the IRB's FAQ says that they will allow it on a case-to-case basis, more and more taxpayers are complaining that they're not getting this particular flexibility. So we got this one hand, health DG says stay at home, stay safe. IRB seems to say do work as usual and give me all the documents. We have to, these are all the things you got to put in. But if your amount is big, I would advise you to go and apply for judicial review so that you don't have to pay these taxes and let the revenue, come and see you in court and try to get the money back from you. But that will be my answer for that question. I think we're nearing the end already.
Yes. One more question, and I think we should end it. Let me just see whether there is.
Most of it are repeat questions.
Repeat question.
To be one, Rishi, last question for Rishi.
Malicious prosecution, Rishi. Is there a limitation period for malicious prosecution from another dear friend of the firm, Mr. Menon? And have you got anything, Rishi?
Yes, malicious prosecution would be deemed to be a tortious action. So you will have a situation where you have to apply Section 6A, the new Section 6A, expectedly.
Therefore, the general rule is within 6 years. But if the plaintiff or the claimant is under an issue that comes within Section 6A, then it is a 3-year period from the starting date.
Correct.
Yes. Thank you very much, dear friends, for joining us. Saravana has arranged for a number of webinars. He's going to start a new series of webinars. I hope you continue to support us in the way that you have supported us in the early years of the firm, and we look forward to working with you and supporting you as well. Thank you very much.